And now, it's The Law Show on CL 650. A comprehensive look at everything you need to know about the law. Now, here's Sterling Fox.
Well, good morning and welcome to The Law Show here on CL 650. We're not going to fight the law here for the next hour, friends. We're going to sit down with a couple of smart lawyers and talk about wills and estates and have some fun in the process. And with just a little bit of luck, you and I are going to learn something this morning. Our guests in studio are John Lakes and John White, who together form Lakes White LLP. They are estate lawyers. They do estate planning and wills. They are in North Vancouver both. Gentlemen, good morning and welcome back to The Law Show.
Good morning.
Morning.
It's good to have you two enthusiastic guys in studio. John White, the junior partner in the firm, the younger partner in the firm from West Vancouver.
West Vancouver.
So the firm is still on the North Shore. Two North Shore guys who ended up working the North Shore in their old neighborhood. You, however, went to school at the University of Toronto for a change of life.
For a change of scene, that's right. I spent 3 years out there. They were wonderful years. I was really glad to leave Toronto and come back to Vancouver.
All right, but lesson learned, right?
Absolutely.
Law degree, and I really want to go back home to Vancouver.
That's right.
And so when you came back, though, you didn't go right into the practice of wills and estate planning and that sort of thing. You went to work for a large firm, and you were a prosecutor for a while, too, weren't you?
I did all of that. I spent seven years downtown doing insurance-type cases and personal injury cases. I came over to the North Shore in 1999. I spent a lot of time working in a bunch of areas, but one of them was prosecuting drug offenses. I'm no longer doing that. I'm doing now more wills and estates litigation than I was back then.
Right.
But I also do other stuff, too. I mean, I do commercial disputes. I still do some personal injury cases. And some real estate cases. So it's a varied mix for me.
And to describe your the way in which you practice law, you are a barrister because you go to court. Not often, but if push comes to shove, no problem, you go to court.
Absolutely. That's what I do.
Okay, now John Lakes is a solicitor. John has been to court a few times, mostly as a witness, and plans to keep it that way. Good morning, John.
Hi. Well, I do sometimes go to court for uncontested matters. So
right.
In what's called chambers, which is sort of semi-court.
Well, that's the judge's office, right?
Well,
so things get done there that you wouldn't do necessarily in open court, right?
No, it's an open court, but it's usually uncontested matters. It's just like something you're getting orders for specific matters,
right.
Such as if you have to get an order dispensing with people, or if you're doing comitees if somebody's not competent. But the contested stuff I leave to John.
And you're a North Shore guy, North Vancouver guy, UBC guy. You're a real homebody here,
well,
aren't you?
I did wander away a bit. You know, I did go to Prince Rupert, and I traveled a bit. And my wife's from Belfast, so I go to Northern Ireland every now and then. So, but I'm able to bicycle to work from time to time, and I miss the bridge traffic, thank God.
Well, no kidding. I mean, and how nice, John, to head to Ontario, come back, and the whole thing comes full circle, and now you have this successful North Shore practice not far from where you grew up. Sometimes it works out, doesn't it?
It sure does, and there's nothing like a 7-minute commute.
Right. Talk to us a little bit. In the last program, we were talking about wills and estates and estate planning and executors and all of those other things relating to wills. But I think in terms of takeaway information from our get-together last month, you had a 40-40-20 ratio, John White, that you spoke about with reference to how many Canadians on any given day in any corner of Canada actually have this whole will thing covered off. Explain 40-40-20.
Well, I won't quote any specific government statistics for 40-40-20, but it's our impression that of every 100 people out there, probably 40 of them don't have a will at all.
Never have had one?
Never have,
okay.
And don't have one now. Another 40 have a will that they wrote 20, 30, 40, 50 years ago,
right?
Which reflected their lives back then, but don't necessarily reflect their lives now. They may be valid wills, but they're not really a reflection of these people's lives today. And the remaining 20 have something a little more up-to-date that does reflect what their lives are like today.
So on any given day in any corner of Canada, John Lakes, only 20% of any crowd would likely have a will. Is that partly, and I'll ask both of you this one, Is it partly because we're talking about our own mortality, and some of us just find that a little squeamish, a little uncomfortable, and would rather pretend that we're going to live forever?
Well, I think that's true, particularly among the boomer generation, which, we still have a difficult time realizing we're no longer 25.
That's true.
And when you realize that not everybody remembers November 22nd, 1963, but it's a way to avoid. Sometimes people have this thing about seeing lawyers too. They have this misconception that we're much scarier than we are, and we cost a lot more than we do too.
Right.
But plus, we all procrastinate too.
But it is, John White, it is dealing with our own mortality. And I got to tell you, it's been a while since I visited the whole will file in my life, and it was an extremely uncomfortable experience. I felt good when I did it because it was important. My life was changing. There were kids. There was assets. There was a lot more purpose and focus, so it made sense to have a will. But I think I'm in that 40%, my friend, of people who once upon a time ago made a will, but it's been so long that the circumstances of my life have changed so dramatically, or 30 years later, that it may not apply. So what happens now if I unexpectedly die, John, and I have this 35-year-old will that's supposed to take care of biz for my family, and that's all there is, assuming, of course, they can find the darn thing in the first place.
Assuming they can find it in the first place, that 35-year-old will, which is going to take care of your business in 2015, is going to reflect what you thought your business was in 1980.
Yeah.
It is likely still to be valid. If it was valid then, it's likely to be valid today. And let's hope that you made a good plan back in 1980, because that's the plan that your executor is going to be following.
Period. So, John Lakes, how many people come into Lakes White and go, I just was sort of sitting down over the weekend and realized, like that guy on the radio, I haven't even thought about my will for decades. Maybe I should kind of get up to speed here and get at least into the new millennium, given the fact that it was dated sometime in 1980. How much updating do you do?
A lot.
I'm sure.
A lot.
One would hope so.
And sometimes when something's happened in their life, not so much with themselves, but a friend's died who's left a bit of a mess, then that's quite often the impetus for people to get their own act together, because they realize that they've still named a guardian for their child who's 40.
Sure.
And their brother who was executor died 8 years ago, and so it's important to review it from time to time. You can have a will that's perfectly valid that was written 20 years ago.
Right.
And you can have a will that was written a year ago that's totally invalid because so many things have changed in your life in 1 year. So they need, even if you have a valid will, you need to review it from time to time to see whether it's still current.
Well, that brings up an interesting question, just to follow up on what John Lakes was saying, John White, and that is, suppose when I did this will, when my little girl was born in 1980, which is true, and I appointed someone, I named someone to be my executor, and as your partner has just said, he died half a dozen years ago, and I haven't made any changes. I didn't think twice about it. So now I die, and the person who's supposed to take care of biz on my behalf predeceased me by a half dozen years. Now what the heck happens?
Well, hopefully you've named a backup executor, or you did back in 1980, and that person is still alive, and that's where we would go first. But maybe you didn't. And if
I can tell you, I didn't.
Okay. Well, then there's no named executor. It's possible for someone, perhaps your daughter, who's now 35,
right,
to apply to the court for an order appointing her as administrator of your estate with the will annexed, which would essentially give her the same role as an executor, but the court would have to rule on that first.
Is it fairly common that these circumstances occur from time to time, and the court has to step in and go, well, that's okay?
Oh, they crop up often enough. Executors pass away, or I mean, that's probably the number one reason.
Or else executors, either they live in California, so they've been told by an accountant to resign.
Right.
Or else people that are surprised and have had no intention. They were never told they were asked to be a named executor, and they have no intention to act as executor.
Right. I wonder if you could comment on something, and this is, I don't know whether it's a myth or not, but there is this very widely held perception that unless you have your affairs in order when you die, the government is going to step in and pretty much take over. They'll take what you haven't identified as to be delegated to somewhere. The government's basically going to step in and seize your stuff and walk away with most of it. Now, how true is that, if at all?
Well, that's if you have no relatives, that's what will happen. So if you don't have a wife, don't have a husband, don't have parents, grandparents, so forth. But if you have relatives up to first cousins, they can always apply for what's called administration. So the government's only the last resort.
So it's not an automatic, then, that
No.
the government takes over?
No, we're not quite there yet.
But a lot of people think it is. You know, unless you get this done, guess who's going to? Christy Clark's going to run your show.
Well,
imagine.
They also think the government's going to get all your money too, which is not true as well. So it's all governed. It's the public guardian trustee would be the bureaucracy that runs your estate, but it's never. They don't seek to do that work, and it's the executor of the last choice. So if you have assets, you worked hard for what you have. You want to make sure whoever handles your affairs when you're gone carry out what you wish to do, and that's why you do a will and you appoint somebody you trust to do it.
But according to your 40-40-20 numbers, 40% of us, and on any given moment, have no will, never have had, never bothered to even go there twice. And so when one of that particular group pops off, John White, the government is the only recourse.
Well, I want to correct that, because there's a lot, I don't have the actual percentage. A lot of people actually, when they're in the dying state, they do wills before they go. So I think there's a lot higher percentage who actually die with wills.
Oh,
what
really?
It is just that if you ask a current person on the street, they may not have a will, but they may have a will before they die. Danger is if somebody waits too late to do a will. So if they've had a stroke,
Oh, right.
it's too late to do a will. So people should, you should, just like you should get life insurance when you're healthy, you should get a will done when you're healthy.
You told us a story over coffee before we went on the air this morning, John Lakes, about the guy in Saskatchewan who had a heart attack, and he was out in the fields on his tractor, and he had some kind of heart attack, and he had no will, but he managed to make a will in his field on the farm. Tell us the story.
Okay, well, in Saskatchewan, they allow what's called holograph wills if they're done when you're basically dying. And I think this took place in the 1930s, and he was run over by a tractor, and he took a rock, and I believe he wrote in the fender of the tractor, "All to Mum." And that was a very famous case because that was accepted as a valid will because it was basically made in the process of dying
Right.
in his writing. And I read recently that the courthouse that it took place, a rural courthouse in Saskatchewan, recently closed down, and they donated the fender to the University of Saskatchewan Law School, where you can see it on display. But we don't have holograph wills here.
Okay.
So
is that old law now that we
No.
you couldn't pull that off in BC in 2015?
You could never pull it off in BC. We now have a thing called testamentary documents, slightly different. But until then, BC law that's the problem with Canada. Every province has different laws.
Right.
We're our own little empires. And you get into Quebec, they have a different legal system as well, too. So just because something's valid in Saskatchewan doesn't necessarily mean it's valid in British Columbia.
We need to take a break, but John White, just before we do, just to follow up on the fact that we are 10 jurisdictions wide and the territories too. If I make my will in British Columbia, but then I move to Ontario and I don't adjust anything, and shortly after moving to Ontario, I die. And everything in the will is about BC and so on. How does that get dealt with in that other jurisdiction, Ontario?
Well, I guess the answer is that if all of your assets are here in BC and your will's in BC, it might not get dealt with in BC. To the extent that I guess you're living in Ontario and accumulated assets in Ontario, you've got a BC will. It really depends on whether that BC will accords with the law of Ontario. There are things that we have in BC
that are very different,
such
right?
as wills variation,
Yeah.
for example, that they don't have in Ontario.
Right.
So if you're going to move provinces like that, it's probably not a bad idea, if you're interested in having an accurate will, to make sure that it accords with the law in the province that you've moved to.
Right. So again, this is the sort of a long way of asking. If you change your postal code, not from Vernon to Vancouver, but from Vancouver to Charlottetown, maybe when you move, you should sit down with a lawyer in your new province and just make sure your paperwork's up to scratch in that province.
Never a bad idea.
Okay. This is The Law Show here on CIL 650. Our guests are John Lakes and John White from Lakes White LLP in North Vancouver. We're talking wills and estates with a whole lot more to come after this.
There's more of the show still ahead. This is The Law Show on CIL 650.